But today we're talking all about that tenant who refuses to pay their fees and what you can do to get your tenant's attention when it comes to paying what they owe, when they owe it, and making sure that everything is taken care of in a proper manner. I want to welcome everybody back to this live. I appreciate those of you who have attended now. We're going to wait a little bit. Hello, James. Good to see you again. And, we're going to get right into it in just a bit and answer some of your questions. For those of you who submitted questions, I appreciate you. I've got a whole host of questions right here in front of me, and I'm looking forward to, getting into these in just a bit. But for those of you who did not get a chance to submit questions or don't even know how to submit questions, if you are a member of our Facebook group, Texas Landlords, you get announcements throughout the week and an opportunity to type in your questions, which we prepare and present here on this live. But if you're joining us live and either didn't get a chance to or thought of something during the live, feel free to add that to the chat. Hello, Adrian. Good to see you there. And I'll do my best to answer your question to the best of my ability through the chat. So let's go ahead, without further ado, get started. We are talking all about that tenant who refuses to pay their fees. How do you motivate somebody? Sometimes landlords find it sufficient that the tenant is paying their rent, but there are additional fees that are sometimes owed, and it's these extra fees that it's hard to convince the tenant to pay, and landlords get really frustrated with this because it is a necessary part of what's ultimately owed, but the tenant just refuses, whether that's late fees, repair costs, maybe HOA fines, whatever the additional fees are that your tenant is refusing to pay. What can you do? What strategies do you guys have for motivating your tenants to get these paid during the tenancy? And this is something that I stress often, that if you're waiting until after the tenancy to collect and hoping that the security deposit is going to be sufficient, you might find yourself really disappointed with the fact that, hey, those fees and damages and everything owed goes well beyond the security deposit. Or worse, you're in a position where not only is the security deposit not enough to cover these things, if you had made an effort before, you actually would be ahead of the game instead of in the hole when it comes to these numbers. You always want to put yourself in a position to be financially successful, not financially stressed. And I'm going to give you some tips to get that done. And so right from the start, you got to know what your lease says about the fees that are owed. Does your lease give certain deadlines for these things? So for example, maybe you collect utilities through your lease, which is not something that I advocate, but in some instances it's the only way. And so maybe your lease says utilities will be handled in this specific way. You want your lease to be explicit. When does that bill come out and when is it due? And what rights do you have if these utilities remain unpaid? You can't just assume that you have shut-off rights, particularly if shut-off is not part of your lease. There are stiff penalties for landlords who go and just shut off water or electricity or gas because the bill remains unpaid. It's not a proper justification. If you don't have the right to do it, you cannot proceed with that right. And your jurisdiction may limit what rights you have. Make sure you understand in the jurisdiction where you operate what rights you have if you're collecting fees for utilities. Because again, the penalties for shutting off someone's utilities without just cause or without proper procedure can be stiff. So what does your lease say about things like late fees and HOA fees or repair costs? How soon is your tenant obligated to pay these things, and what are the consequences for them not paying? If you're not an expert in your own lease, you're already 2 or 3 steps behind your tenant. And one of the reasons you may not be collecting these fees is because you're not exactly sure how to do it or what your lease actually says about it. And so you either let it go under the table, just let it slide, it's not a big deal, or it's a big deal to you and you just don't know what to do about it. So step one is dig into your lease and find out, what does your lease say about these additional fees? Whether it has to do with pets or whether it has to do with other kinds of things that just pop up during the lease term. How do you charge them, and what can you do if your tenant refuses to pay? Well, one great idea, no matter what your lease says, is to issue notice. And so you may not be familiar with the procedure, but I hope you're getting familiar by watching this channel and just from your own years of experience, familiar with the process of delivering notice to your tenants. What does that notice look like? How diligent are you with getting that notice into the hands of your tenant in a timely manner and in an effective manner? If you're doing this every single time, then I assure you, you're becoming better at landlording, and you're putting your tenant in a position to either comply or to leave. And that's essentially what your notice should explain. It points back to the lease, and it mentions, look, repeated instances of these kinds of violations that lead to these fees could ultimately result in an eviction. And if your tenants are properly notified, you're likelier to be able to collect what's owed to you early, as opposed to waiting to the very end and hoping that that security deposit covers the day. And then finally, you have to be willing to evict. Even if rent is getting paid, if you're missing out on fees for some reason, or if your tenant is causing additional damages and you're not sure how to collect them, you got to know how to step up your game. So one way to do that is by utilizing your application of funds clause. It's one of the favorite sorts of gems that are in good leases that allow you to apply these unpaid fees or to pay them off from a subsequent payment in rent. So here's how it works. Let's assume you've got late fees from last month. You've got some kind of pet damage that you repaired and you notified your tenant of, and then you've got an HOA fine for $100 for some repeated violation that the HOA has warned you about, has sent letters over, but that hasn't gotten fixed. And so in a given month, you send notice to the tenant and say, look, you need to pay this off in 7 days. You owe X, you owe Y, and you owe Z. And they go completely silent, don't pay anything. But the following month, they pay a full month's rent, and you deduct those amounts from the payment of rent. Your application of funds clause should allow you to do this. And if they don't cure the remaining rent balance after you give them notice and say, look, your rent is now short because all those fees that I gave you notice of have been cleared out by your payment, but you left an amount of unpaid rent. If they're unwilling to pay that rent at that time, you have to be willing to send that notice to vacate and proceed with an eviction. Now, certainly there's always going to be some issue or potentially there's going to be some valid basis for the tenant. But if there is none, proceed to the eviction. If you're not willing to do that, understand that your tenant is likely going to carry over that debt month after month after month until you finally decide to enforce it. And guess what? If you wait so many months that a court says, look, this isn't a serious fee to you, otherwise, you would have handled it more seriously. I'm not going to enforce this eviction now that 18 months have passed and you're just now seeking to recover it. I just don't think it's authentic. And because I don't, I'm not going to allow you to enforce it. Don't put yourself in that situation. If you're going to enforce it, make sure you're willing to go all the way, even to eviction. Now, I'm not saying you have to do it definitely in the first month, especially if they're paying rent. But after you've given an adequate amount of time for your tenant to pay, you may have to raise the stakes. In fact, it's always best for you to mention these things before the lease ever begins. It's a common thing that I mention to all landlords. Make sure you're having these discussions with your tenants before the lease begins, during the lease, and as it comes to an end. This is something you are serious with, and you do it consistently from beginning to end for every single tenant you have. So landlords, I hope this was helpful to you in terms of collecting fees that a tenant refuses to pay. I'm going to go ahead and jump into the questions. If you've got a question, don't hesitate to add it to the chat. I'm looking forward to hearing from you. So the first question comes from Marcy Haas. She says, the tenant is disputing the security deposit withheld, and demands the full return of the deposit. If taken to the small claims court, what determines what he or she said in the situation? They claim that the conditions were all pre-existing or normal wear and tear due to landlord negligence. It's a great question, Marcy, and I'm happy to answer you after my cool, refreshing drink. All right. So the burden shifts in this case. So generally speaking, when a plaintiff brings a case, the burden's on them to prove their case. But in a wrongful withholding case, the burden shifts completely to the landlord. And so now the landlord has to prove that every single deduction that they made was reasonable. So how do you do that? Well, I never tell landlords to rely entirely on that inventory and condition form. It's not great evidence because you leave it up to your tenant to determine what was or wasn't wrong with the unit. And they can easily just make the claim, look, this thing was wrong, but I had not discovered it within the 3 or 4 days that I had first occupied the lease. And that's a pretty valid statement they can make to the court. And many times the court isn't going to allow you just to rely on that inventory and condition form. So I strongly recommend you do a few things in addition to that. The inventory and condition form is great, but you want to do better. And one thing you can do better is for you to have proper documentation of all the things you did before the tenancy began. Did you pay somebody to paint the place? Did you install new carpet? Did you buy new appliances? Keep all of those receipts in a binder where all of the pertinent information for your tenancy exists. Keep it all in one place so that if you ever have to recall it, you can easily say, yeah, I bought that stove in this year, and within 18 months, it was destroyed by the tenant. I deserve a brand new stove, or close to it, because there's no reason why it should only have lasted a year and a half if the use had been normal. So my proof that this goes beyond normal use or beyond ordinary wear and tear is the age of the unit. And so the receipts and invoices that you used to cover costs prior to the tenancy, that's one thing. The second thing is always going to be, photographs and video. And so you have full control of the unit before keys are ever handed over to your tenant. Take pictures of everything: the floors, the walls, the ceilings, the appliances, each of the bedrooms. Make sure that you have proper documentation of the walls. Inside the home, you have documentation of the condition. Outside of the home, what does the grass look like? The shrubs, what's the condition of the fence? So all of these things are important and are likely to be claims. What's the condition of your air conditioning unit? I would even, before you surrender the unit to a party, make a mark on the AC filter with the date that you install it. So put your initials and the date. Brand new clean AC filters. So when you come 3 months later, if it's the same filter, document that. Give the tenant notice. Look, I was here over 3 months ago before you took possession of this unit, and this filter hasn't gotten replaced once. If your lease specifically requires monthly or some change every 2 months, well, then you can point to this as an absolute non-normal use or violation of the lease. And then if you come back 6 months later and the replacement filter that you put with your initials and the date is still there, now you know for sure they haven't done anything, because now 6 months have gone and it's the same exact filter. But with your documentation, you're able to prove it. Without it, it's just your statement. So make sure you're able to prove with receipts the things you paid for, the services you paid for beforehand, and then with photographs, the condition of the property that you left it in right before the tenant entered. And then, of course, you're going to want to utilize the condition and the inventory and condition form as another layer. Now, when you're establishing the difference between normal use and ordinary wear and tear and non-normal use, that's tough. That's always an opinion. And so it has to do with what went wrong and to what extent it went wrong. If you're talking about worn out carpet and that carpet's already 8 years old at the beginning of the tenancy, good luck getting any value from it. It's unlikely that you're going to get anything because that's already pretty old carpet. Even if it was in okay condition, the fact that it's now worn out after, say, 10 or 11 years isn't going to get you a whole lot of sympathy from the court. It's probably had its time and no longer has value. So of course you were going to replace it anyway. You can't be compensated for replacing something that essentially has no value. Understand these issues, understand these complexities. What sorts of things are common damage? Little holes from nails in the wall, very common. Giant holes from fists going through or other objects going through the wall, not common. And so you can definitely be compensated for those damages where you probably can't be compensated for tiny little holes for nails. And so I wouldn't go too ticky-tack on those kinds of claims. A broken window, there's almost no way where normal use results in a broken window, so that's an easy one. A worn-out garbage disposal, again, it's going to depend on the age of the garbage disposal. If it's the same one that's been there since you bought the house 15 years ago, you just can't charge somebody for it once it finally goes out. That's the definition of normal wear and tear. Over 15 years of use on an appliance, who gets that anymore? Old appliances are eventually going to go, and you can't blame that last tenant for 5 or 6 previous tenants that used it as well. And so those kinds of costs can't be assessed. So make sure you understand the difference between ordinary use and normal wear and tear and anything that exceeds that, and that you can demonstrate to the court why you deducted these things and why the acts of your tenant exceed normal use. And one way to do it is by showing photographs so you can show a distinct difference. This is what the place looked like before. This is what it looked like when I got it back from my tenant. Drastic difference, immense damage, not normal use. And if you had certain things in your lease, for example, cleaning fees that were there that were there prior to the lease, that the lease mentioned have to be done at the end of the lease and were not done, you can demonstrate it's in the lease and here's my receipt that I paid for it. They cannot prove that they did the same. In fact, my evidence shows they left the house a mess. So what evidence you have is extremely important. And remember that the burden shifts to you as the plaintiff. The burden shifts to you as the landlord in a wrongful withholding case. So it's important to understand that fact. Next, Alexander Valentin writes, I'm a property manager and my landlord has asked me to notify the tenant that they're responsible for maintaining fruit trees in the backyard. There are 3 overgrown fruit trees, guava, lime, and pomegranate. The lime and pomegranate trees are about 12 feet tall and seem reasonable for the tenant to trim under the lease's landscaping clause, which states that the tenant is required to ensure yards and all landscaping are appropriately maintained. However, the guava tree is approximately 20 feet tall with branches extending over a plastic fence into the neighbor's yard. Due to the size, height, and proximity of the fence, I'm concerned about safety and liability if the tenant attempts to trim it or hires an unlicensed landscaper who then gets injured. If the landlord insists on having the tenant trim the trees, what potential liabilities could arise for the owner? How would you recommend handling this to protect the landlord while still honoring the lease terms? So I've had this question come up in the past. I've actually litigated this very provision in leases, and landlords are not. The fact that something is in a lease doesn't mean that landlords can get everything that's there. Landlords are subject to the enforceability of the lease and whether the court's going to see that something like this was a reasonable maintenance, which again is going to come to what was the condition of these trees before the tenancy? Can the landlord prove that condition? And what does it mean to maintain that condition? So if the trees were overgrown before the tenancy began, then all the tenant has to do to maintain that tree is to leave it overgrown. Now, if it's well manicured and neat, and the landlord specifically says, like I mentioned before this, I had an arborist come out once every year and do X, Y, and Z. I expect you to do the same. Here's my receipt. I'm keeping it in the binder. you property managers should enforce that they can bring out the same arborist. I'm cool with this guy, or have their own, as long as they maintain what I have done. And so, be clear in your leases, landlord and property managers, that if you want your tenant to maintain trees in a certain way, that you can establish a record of your own maintenance, and that you can suggest how the tenant gets that done. You're being unrealistic if you've got overgrown trees that you want them to assume the responsibility for because your previous tenant didn't, or because you were the previous owner and you'd rather pass the buck to somebody else. That's just not the way that it works. If they took it as is in a particular condition and you're asking them to maintain that condition, that's all they have to do, is leave it as they found it and not any worse. So, I mean, the idea that you've got overgrown trees and want them to fix that, that's not a reasonable request. So I would turn to the lease and turn to the past practice of the landlord to see exactly what they did, to establish what maintenance of these trees is actually supposed to be. Because otherwise you don't have a reasonable expectation for your tenants. Okay, so we've got James. How do you handle a deposit paid by two roommates? Let's say a couple breaks up and one roommate leaves. How do you handle the deposit return when the last occupant leaves? Well, again, my recommendation is the same. What does the lease say about this? Does the lease say, the payment is issued back to all of the tenants? A good lease generally says that the payment will be issued to one place in the name of all of the tenants who signed the lease. And so if that means they have to resolve how that's split up, that's their issue, not yours. Make sure you follow the lease. And if a lease is amended, that section should be modified as well. If a tenant is leaving early and they're waiving that deposit, that's an important provision to make sure. But remember, if you're letting somebody out of the lease, are you also letting them off the hook for any liabilities for damages that might have surfaced? You certainly don't want to release someone and then, there's all sorts of damages and they were the one with the deeper pocket than the remaining tenant. So, I don't recommend, letting people out early. Instead, I would keep everybody on the hook, but that means that when the deposit's returned, it's returned to everybody, and you just leave it to them to settle out. So, large in part is going to depend on what that lease says. James goes on to say, one occupant paid the deposit, but the other roommate is saying they paid half. That, again, what does the lease say? Because generally speaking, they have joint and several liability. So it doesn't matter who pays what. All the payment goes together in favor of all of them in equal shares. And so all the obligations also belong to them in equal shares. But what the law says is we don't care which one of them pays. We just know they're all equally obligated and they all equally receive all of the benefits that are attributable to that lease. So whoever paid a larger portion or a smaller portion, none of that's relevant. They are all required to pay the rent, and they're all entitled to a refund. And how they split that up is between them. So, Alexander writes, hello, Mr. Garcia. Thank you for answering those thoughts and questions. You're very welcome, Alexander. A writes, can part of the move-out repairs charged to the tenants be completed at a later date? Do I need to provide a quote or written communication with the contractors to justify those charges? So, in a word, yes. The final bill can be updated after, even longer than 30 days after the tenants have surrendered the property. That happens from time to time. So let's say, for example, a tenant leaves at the end of month A, and before the end of month B, the 30-day limit, you've gotten proper surrender and a forwarding address. You've sent out notice to your tenant as to the breakdown of that security deposit. And let's say your estimate was the repair is going to cost $500 for the one deduction that you had, and you're holding a $2,000 deposit. So you refund $1,500, but it turns out the repair ends up exceeding the $500. Can you send a demand letter to your tenant saying, hey, it turns out you actually owed me more than I originally deducted? Yeah, I mean, that's possible. Whether it's worth it or not is going to be completely up to you. Where this tends to happen is where you've got so many deductions that they exceed the deposit, and then your tenant maybe sues you for wrongful withholding, and then you countersue for even more than was outlined in the original itemized deduction. Is that legal? And it definitely is. Additionally, it could just be that your original estimate was, for a $2,000 deduction, $2,500 in damages. And so you tell your tenant, look, you get no refund, your damages exceed. And then it turns out it's more like $6,000 of damages. And now you want to go after your tenant. Yes, you would still have a viable cause of action for the full amount, even though you discovered it afterward, because during the 30 days, you knew you had at least the amount of the security deposit in valid deductions, and you gave your tenant proper notification of that. So James says, thanks. James, you are very welcome. I have some tenants asked to move in some items before they sign the lease. I don't do this. What is a good reason to tell tenants why I do not allow this? Well, number one, it's the effective date of the lease. And so if the lease doesn't begin until, day one of the following month and they want in a little early, so your rights don't start until day one. Even if we've already signed the lease, your rights don't begin until then. Just the same, if they stay beyond the last day of the lease, guess what? They owe you rent for those additional days. They don't just get them for free just because they're in the process of moving. It's understood that if they're occupying the space outside of the lease term, they have damaged you and owe you money. So let us continue. Aaron Stanchik says, that's happened to me too. Yeah, unfortunately, it happens a lot. So next question is from Tammy Heisler Guyton. If my tenant sublets a room to someone without my permission, that's bad. That person then doesn't pay rent to him. Can I evict the sublet based on no permission for me to move in, not on the lease? I think he means for him to move in, not on the lease. The loss of money to the tenant is on him. However, I still want the sublet up. Okay, so first of all, you have no privity with the subtenant. The subtenant and you have no contract, and so he doesn't owe you any rent. The fact that he owes rent to somebody else means only that person can make a claim for rent. What you do have from your original tenant is probably a massive and substantial breach of their lease. So the law doesn't usually allow you to pick and choose who you are evicting. If the tenancy all stems through the same agreement, in this case, the original lease and now a sublease, you get rid of them all. And so your solution is everybody goes, but the named party in your eviction is your original tenant. Remember, because you don't have privity with the subtenant, you want him gone, and he will be gone because your writ of possession will say, tenant A and all other occupants, as far as you're concerned, his subtenant isn't your tenant. They are a mere occupant there because of the tenant. And so, yeah, you'd get rid of all of them that way, Tammy. Okay, A says, thanks, Ernie. Very helpful. If the tenant requests receipts for future repairs that were deducted from their deposit, what should the landlord provide? I don't think there's any reason to hide the ball. If tenants are suspicious that your itemized list is not enough, I don't send it in the initial itemized notice. But if they say, hey, I want to know because I'm thinking of suing you, send them the receipts. And let them know, look, if you attempt to sue me, I've got damages that exceed your security deposit. And so because of that, I'll be forced to countersue you. So, but here are my receipts. Feel free to examine. Don't ever send your originals. Savannah Jackson writes, hey, Ernie, do FHA ESA rules apply if you only have one property? They might. So there are certain exclusions in certain instances, and one of those instances has to do with whether you have 3 or fewer properties that you lease within a given year, or whether you sell only a certain number of properties, or you're a member of a religious organization. There are other limitations that serve as exclusions from the Fair Housing Act. But what I tend to recommend to landlords is, start getting used to enforcing these rules as though they apply to you if your intention is to grow your business. If you've got 1 or 2 rent houses and your goal is to have 5 or 6 or 7, then just start practicing as though you do. Get into that habit. You're better off knowing it now and dealing with it now than forgetting and then being subject to the FHA. And now all of a sudden you're having to deal with a federal claim against you. So, get used to it early if that's your goal. If you've got 1 rent house and you're never going to have any more than that, and you don't list with a broker, then you're probably subject to an exception. But again, for those of you who are planning to do more, likely to have more, just start operating as though the FHA does fully apply to you, because it actually might. And so you kind of sidestep all that by just, lining up with the law right from the start. All right, next question. Victoria Crystal Rodriguez writes, what can an owner do when dealing with an individual, in this case, an abusive family member, pretending to be the owner of your house and signing leases with tenants? The most recent occurrence of this was while evicting my current tenant. The individual showed up to the eviction court and either shortly before the date or after went ahead and forged a residential lease agreement with the tenant, who happens to be a realtor. Well, this sounds like a real interesting matter, but Victoria, fraud is fraud, and in whatever permutation fraud exists, this is what courts are for. And so you have fact finders who make determinations based on the facts. And so the court is set up to review things like who holds the title. If a fake landlord is out signing leases, it's up to them to establish, well, where did they ever have the authority to sign this lease? And so if they can't establish for the court, to the satisfaction of the court, that they ever had this authority, and if the tenant shows up with, a fake lease, and this happens from time to time, where people show up with inauthentic documents, you have to have a stronger case. And one of the things that I recommend to landlords all the time is that you show up to trial more prepared and better suited than your opponent. By doing this, by having a documented notice, by having a clean ledger, by having great records, you're able to establish for a court the truth in a far better way than any lying opponent could. If they're lying and they're pulling off a better case than you because they're better prepared than you are, that's always going to be a problem. But as long as you have the upper hand because you have the truth, you're likelier to prevail. And, people are going to try to lie all the time. It happens, and it's unfortunate. I've seen it way too many times to say, oh, that's not a common thing. It happens. But definitely, if you are better prepared, it's a lot easier for the court to take you seriously than someone who's just showing up with a sack of lies. So, okay. Ariana Hamilton asks, the tenant moved out Friday, July 4th, when the lease ended. However, he left his washer and dryer behind and couldn't get them picked up until July 14th. The appliance lease company picked them up on July 14th. We had a showing on the 17th, and the potential tenant noticed a lot of water all over the floor. I had a plumber come out and advise that the appliance company left the valves of the washer lines open and only put the plastic caps. The water leaked until it was found by the showing agent. What are my rights? Can I withhold the security deposit to see if the appliance company will cover the repair? Can I charge the tenant from the security deposit for the time past the lease that left the washer and dryer on the property? I used a standard Trek lease. This was before I knew your firm and purchased a lease through you guys. Okay, so, and by the Trek lease, I'm presuming you mean the Texas Realtors lease. And in that lease, it does talk about, different elements. One of them is holdover rent. The holdover rate for rent in the Texas Realtors lease and in other leases is 3 times the monthly rent. And so if someone is there beyond, and by being there, that could include their personal property. They have not fully vacated and they still got personal property there. You can charge them up to 3 times the normal rate of rent on a daily basis without demand. In this case, if those appliances were there 10 extra days, I mean, essentially it's like an extra month of rent. So that's damage calculation number 1. Damage calculation number 2 is, can you reasonably deduce that this harm was caused by either the tenant or one of their agents? In this case, the company that came in and removed the appliances. I don't think it's a difficult case to prove that they mishandled the unit and left additional damages. So I would get an estimate for the repair costs of those damages. I would send it to both the tenant and to the repair company or the appliance company in this case, and see who comes up with the money. So yes, you can charge for the additional rent. Review your lease to make sure that your holdover provision allows you to charge, as I've explained, what is typical in this lease, 3 times the monthly rent per day for each day they stayed beyond the date of termination. And then, ultimately, what are the full extent of your economic damages? Make sure you sent written notice to your tenant. And in this case, because there are additional damages because of the water, that I would also send notice to that appliance company if you know who they are. If you don't, then of course it goes to the tenant, and you can make reference in your notice to the appliance company. So that's what I would recommend there. A says, sorry for the confusion. I meant when a repair hasn't started within 30 days of the deduction cost from the tenant's deposit, only a quote is available, not a receipt, but the tenants are asking for proof. Well, that estimate or that quote is also evidence. The final trial evidence would be the receipt where you paid in full to conduct that repair. I don't recommend that landlords show up to trial with just an estimate, especially if years have passed by. Make sure that you've shown that estimate to your tenants, and that ultimately when the repairs are done, if a claim has to be presented to the court, you're showing up with that receipt paid in full. You're very, very welcome. That's very nice of you, thanks. And that's a cute pair. Let's move on. We got Christina Allen. After about 11 years of being landlords, we had our first ever eviction for non-payment. The tenant ended up causing intentional damage to the property as well. We had to pay thousands to make it ready again. Besides having a collection agency attempt to collect on back rent and damages, I'm not big on these collection companies. I've never seen one that does anything good. But let's move on. What other things can we do so that other landlords and PMs, property managers, will be aware of tenants such as this? Where can landlords like us move more thorough? How can landlords like us be more thorough in our vetting process to avoid tenants with a history of non-payment and intentional damage? So there's no bad tenant database. So that's one thing. The other part would come from evictions and other civil judgments that would come against tenants for these kinds of damages. The real question is, can you collect from this particular tenant? And chances are no. If you've got a judgment-proof tenant, that's somebody that you could have a judgment for $50,000 and you'd be able to collect none of it. I don't know how valuable it is to go after a judgment like that. And so if you're asking what can be done to better vet these tenants, one thing that I strongly recommend to landlords when they're in the screening process is the Two Landlord Rule. If every tenant comes to you and cites 2 different landlords, their most immediate landlord and the landlord before, I would skip right over the most immediate landlord for this very reason. That landlord may be looking for every reason to get this terrible, terrible tenant off of their property. And so they're going to gush about that tenant. Oh, yes, I love so-and-so. You're going to love them. You should sign that lease right now. Have you signed it? Go ahead and sign it. Let them move in tomorrow. I can't wait for you to have them. Because they've been terrible to them and they can't wait to get rid of them. And they'll say or withhold information, say really good things, withhold all the bad things to make sure those people are gone. So the most immediate landlord is the least trustworthy of all landlords. However, the landlord before them, they're gonna tell you the truth. They're going to tell you just how terrible those tenants were and the kinds of things they did to their property. And hopefully, because they have nothing to gain or lose from being truthful, hopefully that call spares you huge losses. And so if a tenant can't produce two prior landlords, the most current one and one before that, that might be a red flag that this is somebody you just can't trust because you can't prove that they are trustworthy. Now, you don't always have people who have two prior landlords. Sometimes, people are downsizing and they were homeowners and now they, for whatever reason, they're going to be renters. And so if they were homeowners for an extended period of time, you kind of can't do that test. But for people who are and have been tenants for a long, long time and have never been homeowners, and they can't produce their last two landlords, that could be a huge problem. Or if there are gaps in between the landlords, again, huge problem, because there's probably a reason there's a gap. And it's probably because they've got skeletons in their closet that they want you to know none about. So that would be my recommendation. Again, collection agencies, I've found just don't do a whole lot to help landlords collect. So I'm not a big fan. M.A. Cumby says, if a former tenant is unhappy about the amount of the security deposit refund, what, number one, is the statute of limitations on their being able to file suit to challenge the amount of the refund? I'll answer that: 4 years. In the state of Texas, you got 4 years. It's a breach of contract claim, and they can raise it within 4 years. Second question, if they cash the security deposit refund check, does this have a legal interpretation that they agree with the amount and can no longer file or win a suit that finds fault with the landlord's deductions? Simple answer is no. Any demarcation on check bears no impact on whether or not a claim still exists, right? You may have heard that internet hack that, your next car loan payment, make sure you write account yada, 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 paid in full if cashed. Again, that has no bearing whatsoever. Even if they put a happy face next to it and do 3 exclamation points and be like, yeah, man, no bearing whatsoever. The thing that supersedes that is your loan agreement. Just the same, the thing that would supersede that statement would be the lease. What does the lease say? What does what does state law say about the damages that were cited? Those things are infinitely more important than any marking on a check. So no, that's not going to have any effect on future litigation. What will affect future litigation is the landlord's ability to prove that each deduction was 100% valid. And so we talked about that earlier. You want to be able to lay a foundation with good evidence, which includes receipts and other things that show the kinds of improvements you made before the lease, but then also photographs and video of the condition, floors, walls, ceilings, appliances, bedrooms, inside, outside, all of that stuff. And then, of course, the inventory and condition form is another assistant in that journey. All right, Marcy jumped back with another question. If a former tenant is a lawyer, ouch. Sometimes these are the worst tenants, absolute worst. If a former tenant is a lawyer, would there be a max amount they could claim as legal charges in court in a security deposit dispute? Well, it depends on the court. So if you're in justice court, the max amount that could be awarded is $20,000. So if they're tripling, let's say, a $5,000 security deposit, then I guess they're maxed out at $5,000 in attorney's fees because you're limited to 20. So there's that. If you're in a Texas county court, you can go well beyond $200,000. If you're in a district court, there is no limit. So, I mean, maybe there's a max, but remember, and your lease probably says as much, you can only be charged for reasonable and necessary attorney's fees. If the attorney fee is unreasonable and was never necessary, then no, they don't come in. And judges routinely deny attorney's fees when there's no finding that they were in fact reasonable and necessary. So the fact that the other side is a lawyer, he would have to show, number one, that he did lawyerly work, and number two, that his rate is reasonable. So, would it be, for example, reasonable for an immigration attorney to charge for their work at the same rate for their immigration work as they would for a landlord-tenant case? Probably not, because their expertise in immigration law far exceeds, I'm sure, their expertise in landlord-tenant court. And so the idea that rate would be applicable, it's not apples to apples. And so, that's where you get into the argument of, reasonable or not. So Maria Lewis writes, once a landlord is granted an eviction through the court, is the eviction automatically listed on the tenant's credit? The simple answer is no. It's never on the tenant's credit, because since 2018, the federal government disallows judgments from evictions to be featured on an individual's credit report. However, if a judgment becomes final, and that's another caveat to your question, judgments are not final until a certain number of days have passed. So in a Texas Justice Court, after 21 days, it is final, unappealable, and the court lacks what's called plenary power to adjust the judgment in any way. So once a judgment is final, that judgment can go through the process of abstract, where a judge signs an abstract, and then you, as the holder of that judgment, can go and file that judgment in the county clerk's records, just like you would file a lien or a deed. You would file that and create a judgment lien against the individual. Now, that judgment lien is findable by creditors. And so let's say that individual is looking to buy a house or secure a loan for a car, and someone who is checking through county records to see if this person has judgment liens on them finds that lien and says, I'm not extending this loan for the purchase of this vehicle or this home until you clear out that lien. That lien serves as a potential threat to my collateral. And that's when I get a call if I've abstracted the judgment, and someone will say, hey, I want to pay off this judgment. I then call my client and say, we got an offer to pay off the judgment. Do you want me to take care of this? It's usually a yes. And then I facilitate the passing of the payment. And then ultimately we release the judgment, and that's the way you clear it off the person's record. So no, it won't show on their credit history, but a recordable judgment will show up as a judgment lien when someone does research of an individual as part of, again, generally some kind of financing. So I hope that helps. I hope that answers that question. I have got one last question for you guys. I appreciate all of you who hung around through the entire live stream. And I'm going to go ahead and get to this next question. But I did want to mention that next week, we are going to be here live again. And our topic for next week is, how can I get this tenant to cover the cost of all these damages? We had a lot of questions about security deposits and what to do after damage is left, and then disputes about those damages from a security deposit. Next week, we're going to talk about how to not wait till we get to that deposit point. How can we do that during the lease term? And so I hope this is helpful for all of you. How can I get this tenant to cover the cost of these damages? The best time to do it is during the tenancy. So let's go ahead and get to this last question. Adrian says, is there a certain time of year I should check in with your office to see if the laws change and the lease needs to be updated? So the state legislature meets every other year. They met this year and made some significant changes, or I mean, not a whole bunch of them, but a few that will have some significance, but that won't apply until January of next year. So typically in the fall of an odd number year or the following January, you're going to see these updates. And I'm going to be making videos here in the near future about those changes and what they mean for landlords coming in 2026. I'm going to produce them in the fall, release them sometime in the fall, and then so that you'll be ready once these changes take effect, again, January 1st of 2026. So here's the last question from Joy Stanchik. She writes, I have a great tenant. They pay rent on time, maintain the house, they're pleasant to deal with. Their lease ended in June, and they verbally agreed they want to stay another year. I wrote a new lease, excuse me, because the old lease did not automatically renew. But they haven't signed it yet. It's July. I've emailed and called them and several times, tried to remind them, but they are dragging their feet. I believe they will sign, but I'm annoyed. And this seems, but I am annoyed. This seems to be on their timeline, not mine. My husband is very upset and wants them to sign right away. He believes we are operating under no agreement. Not true. The previous agreement is still in existence by operation of just you not having kicked them out yet, especially if you collected rent in the month of July. He believes we're operating under no agreement and is nervous. If something goes wrong, we have no lease to fall back on. Again, the last signed lease still controls, I promise. What are the implications for this annoying in-between lease agreement time? Does the old lease have any weight if something happens? Is there anything we should be aware of or concerned of during this time? We don't want to do anything drastic. You might need to, but we are frustrated and we don't have power because they have possession. Well, you do have power. And so here's what I would strongly recommend. You have to make it absolutely clear. And this would have helped to do with the lease extension. And this is actually quite common, that the lease extension itself is notice of the following. Either A, you are free to sign this lease extension, or you are free to sign the attached brand new lease. Otherwise, your month-to-month rate will be X, and it's usually, bloop, really big. Some astronomical, well, I don't know about astronomical, but some substantially higher amount to motivate them to sign the new lease. And by giving them the either or, it's absolutely certain, you've got a motivation for them to sign it, or they've got to pay the higher rent amount. And as long as they're willing to pay the higher rent amount, that's okay. But if it starts to feel like, I don't think they want to be here for a full year lease, but they're not giving us notice that they're moving, then you have to decide, are we cool with the higher rent rate on a month-to-month basis? Or do we just send our own notice of termination and say, we're going to go ahead and just cut ties. We rescind that lease offer, and we're just going to end everything in 30 days. So can you still do that now? Yes, you can. But you got to give at least 30 days or whatever amount of time the previous lease had. It sounds like it didn't have a limit because it didn't have an automatic renewal. So by default, you've got 30 days. So what I would say, so this doesn't drag on into September, because you can't do anything about August. August is set. I would say, look, if we don't have that signed lease by within 30 days, consider the new rent rate beginning September 1 to be big, right? Again, a substantial increase to motivate them to sign. But you can also consider the current arrangement 100% terminated. So sign the lease with the new rent rate, sign the lease with whatever the terms are, or pay the new month-to-month rate, which is a big one, or leave at the end of August. I think that's going to be motivation that gives plenty of time. You've got, 5 weeks at least before the end of August. And so you can't say this is unfair to them. They've also had most of the month to sign that lease. And so you would have given them 2 months to enter into a new lease agreement, or to agree to a much higher rent rate, or to pack their bags and skedaddle. So I think it's perfectly fair to do it this way. In the future, I would recommend having this, either or scenario, so you're not in a precarious situation. And you can have it subject to day one of the new lease term, right? So I know it's coming to an end and it will not continue. So either A, the month-to-month rate, if you're still here, will be a massive amount, or B, you sign the new lease. Otherwise, at the end of the month, because I'm giving you at least 30 days notice of non-renewal, right? You got to go. And so, again, these are some creative ways of handling these sorts of things. After the fact, again, your base amount is 30 days. And so I would send that notice out, Joy, and, it's unfortunate that they're treating you this way, but maybe by, giving them this motivation, you'll kind of grease the wheels and help them along. Marcy B says, thanks for this. Can the tenant take you to another court than small claims court for $1,000? Yes. So the minimum is $500. So yes, they can raise it in either the county court or in the district court. But the small claims court tends to be the best place to put a $1,000 claim. Why they'd want it in a different court, I don't know, but they could. Aaron Stanchik writes, thank you so much. Great idea to raise the rent on month to month. You're welcome. Guys, I appreciate you, especially those of you who hung out all the way to the end. I look forward to seeing you next week when we talk about collecting for damages caused by tenants. I want you to have a great rest of your week. And until next time, landlords, happy leasing.